Okay, ladies and gentlemen, ladies and gents, we are inside of a Starbucks once again. Stopped up here because I had to do some downloads and some uploads and some inloads and some outloads, and we're downloading a TV series called John Doe. You ever heard of it? Ever seen it? I never watched it, but I started watching a couple of episodes and it was alright. Plus, I like the actor because he played in several series that I frequently watched. Okay, got that going. Won't be able to download all of them today. It'll take care of it some other time. You know, there are quite a few people who are concerned, worried, and surprisingly so. They don't need to be. But I don't want you to go. Ladies and gentlemen, I don't have a choice. Let me show you why. You got an ear? Well, then you need to hear what I'm trying to say. If anyone has an ear, let him hear. If anyone is meant for captivity, he will go into captivity. I cannot avoid this. I've always known this was me, especially ever since the choosing, that it was referring to me. Want to prove it? Watch. If anyone will kill with the sword, he must be killed with the sword. This is where it calls for endurance and faith on the part of the holy ones. Well, I have faith, and I will endure, and I am one of the holy ones. Whether people want to believe that or not, they knock yourselves out. Don't care. But that's the reality, that's the result, that's why I am not concerned. Now, I wanted to talk to all of you about the arbitration because we got a lot of people who are concerned about the arbitration, which doesn't make any sense. All of the videos that were done, well, they don't trust me. They want to verify to make sure that it's possible and make sure that this is the way to do it. Ladies and gentlemen, as I eat on my carrot cake, I don't care. Whether or not you understand it, it's not the point. Whether or not you want to participate, that's not the point. We are not going to put everything on hold so that you can catch up. We're not going to put everything on hold so that you can understand. Because I, and don't take this the wrong way, because some of you are going to take this the wrong way, and that will be wrong. But the world has never revolved around you. As a matter of fact, you are not the sun of my world or anybody else's world. So please stop thinking that you are so important that everybody has to stop until you get a grasp and you get a handle and you understand things. It doesn't matter whether or not you understand. If you don't understand, that's too bad. That's you. That doesn't mean the whole world has to come to a halt because you don't grasp, you don't understand. Okay? The fact that, well, I've been looking for the Bradley Christopher Stark stuff and I haven't found it. That's too bad because we put it up on the website. Well, I've been looking for it for the United States Congress and they say it doesn't exist. That's all right. You know what else they said didn't exist? They said that there was no smoking gun. They said that 9/11 wasn't an inside job. There's a lot of things they say. So you can believe them and that's fine. I don't care. So those of you who are working through the process, there are two things you need to know. As we stated, as a matter of fact, I'm going to take the time to pull up one of those agreements, so you guys give me a second for one moment. Now, what we're about to pull up is an actual, oh, well, this is the appeal that I'm writing in advance. This is an actual case. This is an actual lawsuit. This is an actual arbitration agreement and contract. This is the original one that I did. This is the one that was sent in originally, and as you see, all of those people, okay, and this is the notice of fault opportunity cure. It says, please be advised that inasmuch as the undersigned has every intention of enforcing the binding self-executing contract, you are being granted a 72-hour period to respond. You must then provide proof as to each of the claims previously received after furnishing proof that you had not received the prior notice which resulted in your default. Okay, many of you are finding that they're ignoring your junk, the stuff you're sending in. They are pretending that it does not exist. And many of you are allowing them to do that. So let me pull up a conditional acceptance that I know will get everybody's attention. No, I don't want the notice of default. We'll do the conditional acceptance. So let's do this one. This is the Defrauded Homeowners of America. Again, those of you who are part of the Defrauded Homeowners of America, you're going to have to be a little bit of patient because we haven't sent out the bill yet. When we send out the bill, it will take approximately 90 days for that to work out, okay, which is 3 months. And then we will then start trying to go after the funds that are in the form of tax credits. Just be patient, okay? If you are part of that group, do not call anybody and ask them because that's my company. So don't be calling nobody asking them, how do you get access to this? How do you get access to that? It doesn't work that way. Some of you are just difficult. You just won't listen. And so we try to help you. Now, this is another lawsuit. This is the Defrauded Homeowners of America lawsuit, and it's against the Federal Reserve. Okay? Now remember, we're going after the value of the contract, but we're going to do something because you guys gotta give me 1 second. I gotta make sure. Yeah, this is not the right one. Yeah, this is not the Defrauded Homeowners of America proof of claim, or is it? Yes, it is. Okay. All right. So let me show you guys so that you can see what's going on because a lot of you don't understand, and so we're going to give you an example of what you can use for your proof of service. Okay, I believe this is it right here. So let me pull up the proof of service, and quite literally this took 10 minutes to produce and do, but you'll see how much information is in it in a moment as soon as we call it an all-purpose proof of service. EON being editor above the age of 18 of the majority and not a party to the action, a citizen of the United States of America, did mail the documents entitled. See, EON is not a party. Okay? Conditional acceptance and notices. We cover both. Now, let me show you why we did it this way. These are all the parties we mailed it to. All of the parties. Alphabet, YouTube, Verizon, State of New Mexico, California, Secretary of State, Google, Security Exchange Commission, the Federal Trust Commission, then you have Fidelity National Vision. These individuals actually told us that they weren't part of the contract, that we never mailed them anything. Okay. U.S. Bank Corp, Caliber Home Loans, United States Secretary of State, the Administrator of the United States Courts, the United States Second Court of Appeals, the Federal District Court. Ladies and gentlemen, do you see how many parties are listed here? That's why we put them in 3 rows, so that we wouldn't take up page after page after page. Deutsche Bank, Chase Bank, okay. We did that. Now, that's their name and addresses. Where's the proof of service? Here's your proof of service. See, this is the tracking number. This is the information showing it was delivered, showing the date and time it was delivered. Why did we do it that way? Pay attention so that you get the message, because many of you are not getting it. It says, not there, we gotta go down. Be 1 second. Sorry, I took a sleeping pill before I left home, and now it's starting to kick in. It says, not that right there, affixing the proper postage and depositing it with the local postal carrier, also being of the age of the majority and not a party to this action, upon receipt, guaranteed delivery as addressed and or local drop box guaranteeing the same as prescribed in law. If called upon to provide this sworn testimony based on first-hand knowledge in the aforementioned events, attesting and ascribing to these facts on this day, April 28, 2019. Ladies and gentlemen, that's basically what it's doing. It's letting them know that you were willing to testify to the facts that's stated in here, and it's also letting them know that you served them via a third party. So you served it up on the third party, and the third party guaranteed delivery. Remember, the United States Postal Service is not a part of the United States government, so they can't be used as a process server. That's what this document is. So we just showed you how to do it. There you go. Now, we're going to move on to this right here. What I need to do is, we're going to go, okay. Yeah, we can do the replacement. We're going to look for court of claims. Okay. We don't have the court of claims here. Let's see. Let's do Nope, don't need that equity. Um, no, not looking for that equity. Okay, so I'm not going to find it here. Let's see. Looking for a different word. Okay, let's do this right here. Proof of claim that summing up the results of the cases referred to above, Justice Hedge, speaking to the Court of Home Building Association, Barth, remarked in 1934 is manifest from this review of our decision that there had been a growing anticipation of public need and for the necessity of finding grounds for a national compromise between individual rights and public welfare. Ladies and gentlemen, the Constitution doesn't speak anything of there being a public need for the necessity of a compromise between individual rights and public welfare. The settlement and consequence contraction of the public domain, the pressure of a constantly increasing density of population and interrelations of the activities of our people and the complexity of the economic interests have inevitably led to an increased use of the organization of society in order to protect the very basis of individual opportunity. Ladies and gentlemen, this is where they say they compromise your rights for that of the public. That's where public policy comes in at. Okay. The idea, what I was trying to show you, it's not in this contract, and that's because this is the Defrauded Homeowners of America. What the Defrauded Homeowners of America is all about is properties. It's not about the actual original contract. So now I got to pull up one of the original contracts to show you exactly what I was talking about. So it's going to take 1 second. Let's see, which one am I going to pull up? Oh, where? Oh, where? Nope. Nope. Proof of service? Nope. Conditional acceptance? Default? Nope. Value of assets? No. Federal Reserve? Nope. Alphabet? Google? St. Francis? Nope, that's not the correct one. Tell you what, let's do this one. We're gonna open folder. This is the Brett Ben Isaac matter. And so we're looking for the original conditional acceptance. And that will be this document right here. Because it's not called conditional acceptance, which is why most people would have missed over it. But no, this one is the correct document. Hold on. And I'm sitting up here yawning because I'm having to talk to you people while at Starbucks sipping on my frappuccino, large frappuccino. It's probably about my eighth frappuccino this week, but there will be no more frappuccinos this week. Matter of fact, I think this will be my last frappuccino. Okay, let's get to whenever it will let me. We're gonna pause you all for a second. Okay, here we go. Show of cause, proof of claim, demand. This is the original contract issued by myself. See that? Issued by myself to the United States government, the United States Attorney General. This is the contract. So let me show you the original contract, especially those of you at the infant estate. We're looking not for settlement, we're looking for court of claims. Oh, come on. Oh, that's because I don't have of. Oh, come on now. You know what? I think I did take the court of claims out. Let's do equity. No, that's too early. It has to be down towards the caveat, and so we got a long way to go. And see, if you, those of you who, if you've done the infant estate, if you've done the incarceration document, yours is going to have equity all throughout. And the reason why it needs to have equity is because the document allows the arbitrator to make a decision in equity. And I think I may have taken out certain provisions, so it may be listed as something else. No, let's see. Okay. Request for summary disposition of any claims or particular issue may be requested and decided by arbitrator, whereas the designated arbitrator shall be chosen at random and who is licensed and duly authorized. In any event of non-acceptance of appointment of the arbitrator and or any physical or mental capacity of the act as an arbitrator, the undersigned shall have the authority, exclusive authority, but authority to select the neutral arbitrators on a neutral qualified pursuant to state and federal laws, the Federal Arbitration Act, and any controversy in a claim arising out of and related herein. Come on now, get out of the way. Let's get rid of this. In any way to this agreement with regards to its formation, interpretation, breach, and any issue substantive, procedurally arbitrability shall be settled by arbitration, and the arbitrator may hear and decide the controversy upon evidence produced, although a party who was duly notified of the arbitration proceedings did not appear, and the undersigned deems necessary to enforce the good faith of all parties because the undersigned retains power of attorney, ladies and gentlemen. So it shall be the undersigned's right to choose the arbitrator. Duly notified did not appear. The undersigned deemed necessary for the good faith of all parties here within, without respect to venue, jurisdiction, law, the forum, the undersigned deems appropriate. Further, the respondents agree that the undersigned can secure damages via tort claim and or financial lien on assets. You all need to know that this tort claim or financial lien on assets, once you get your arbitration award, you have to follow the process for placing a lien on property. You'll have to do your own research on that. I am not going to be able to provide that for you. You'll have to do your own research. But once you get your arbitration award, you can start liening properties. Let me show you something that will give you an idea of what's going on. This is an actual true story. The banks were messing with this gentleman and his property, and he went and he filed paperwork, a contract against Bank of America. They defaulted. He called the sheriffs to evict Bank of America from their property. He had a writ from the court, and the sheriff came to evict Bank of America from the property. Let's do this so that we can get this taken care of, because that shouldn't be a problem. I should be able to connect, but I do see the speed has reduced considerably. I am at a Starbucks, so I do see at least one person, maybe 3 people playing games, so it's a bandwidth issue. And so it'll be just 1 second. Oh, and plus this should be finished. Yeah, that's what I thought. I was downloading this right here because I hadn't seen it. So that's the other reason why I came up here, because I wanted to take a look at that. I don't need the rest of you. I need you. So 1 second. What I want to show you is just the video so that you guys will go and watch the video. Will you be able to look at the paperwork he filed? I don't know. But all I know is you will need to you do the bill, you put the lien on the person's property. You have that right, because an arbitration agreement is an arbitration agreement. If they say that your arbitration agreement is bogus, or if it's this or if it's that, don't listen to that. You don't have to listen to that. What you have to do is you have to understand that you have to stand by your agreement. So what's happening this week, we have an arbitration agreement. They want to ignore it. That's why I put myself out there in the middle of the street for everybody else to show you that the cars are not real. That's right, I put myself out there in the middle of the street to show you that the cars are not real. Okay. See, Philadelphia man forecloses on Wells Fargo. And this is homeowner forecloses on Bank of America. Ladies and gentlemen, this is 7 years ago, 8 years ago. They can't change the laws to stop you from doing it. So let's watch this one.
As a foreclosure defense attorney, this is sweet justice.
This is the video.
The tables are turned. Instead of Bank of America foreclosing on a home.
Look, even called the movers out and everything. Sheriff's detective. They're just sitting right there.
A homeowner has deputies foreclose on the bank.
Bank of America filed foreclosure papers on a homeowner who didn't owe a dime. They paid for their house with cash.
Renee still live at the Bank of America branch on Davis Boulevard in Naples with this story you'll see only on Wink tonight.
This is about a family who fought back and won. Their foreclosure nightmare started when they bought a house in the Golden Gate Estates owned by Bank of America. Like you said, they paid cash, so they never had a mortgage. Well, Bank of America fouled it up somewhere along the lines and actually tried to foreclose on the family. And what happened today, you're just going to have to see to believe. Movers, a truck, and an armed deputy, all while a nervous homeowner stands by and waits. This is normally what you'd see when a person's being foreclosed on and their property seized by a bank. But today, it's the other way around.
They've ignored our calls, ignored our letters. Legally, this is the next step to get my clients compensated.
A Collier County judge said Bank of America had to pay Maureen Nairges and her husband's legal fees after the bank tried to foreclose on their Golden Gate Estates.
Now let me stop this right here. Do you see how it said the judge said that they had to pay for their legal fees? Well, you guys have a judgment from an arbitrator. You don't need a judge to place a lien. You don't need a judgment from a court. All you need is the decision from the arbitrator because it's a valid decision. If they take it to court, the court has no other choice but to enforce the arbitration agreement. Okay, let it play.
It's property, but they paid cash. The courts agreed they never had a mortgage to begin with. After more than 5 months, the bank still hadn't paid up. So the homeowner's attorney did just what the bank would do to get their money, seize their assets.
I instructed the deputy to go in and take desks, computers, copiers, filing cabinets, including cash in the drawers.
Outside the bank, several deputies stood by with movers ready to start hauling out the bank's office supplies and furniture. Inside, the homeowner's attorney was locked out of the bank manager's office by deputies, while the bank manager tried to figure out what to do.
He was visibly shaken. Having two sheriff's deputies sitting across your desk and a lawyer standing up behind them, demanding whatever assets are in the bank, it can be intimidating. But so is having your home foreclosed on when it wasn't right.
After about an hour, the bank finally cut a check.
As a foreclosure defense attorney, this is sweet justice because this is a symptom of a larger problem.
Now, the homeowner's attorney says that he sees mistakes all the time in foreclosure court where banks do not do their due diligence, and it winds up becoming a very lengthy process for the homeowners. He says he can only think of one other time where an attorney, the deputies, and a U-Haul came to a bank before ready to seize property. That was in Tampa. As far as Bank of America, they issued a statement saying that they apologized for the wait on the payment. They issued a notice to pay from the attorney that was working on the case on their side, but they didn't know the attorney went out of business. We'll be reporting live here in Naples. Renee Still, Wink News.
Now, we all know that was a lie. Now, let's do this one. This is the one that I am very familiar with. This is to let you know that you do have that right, especially if you pay attention, have a legitimate
this morning from Philadelphia.
claim.
Hey, Patrick.
Hey, how are you?
I'm doing well. So explain this for us. You actually had a home that Wells Fargo came to you and said, look, you need to take out a homeowner's insurance policy that you don't think it's worth the value of your home. What did you do to Wells Fargo in response?
I told them I wasn't going to renew that policy that they were having me renew. I had an insurance policy on my house, which I had bought for $180,000. And Wells went to the insurance company and said that they wanted me to insure for $1 million. And as you can imagine, the premium on a policy like that is through the roof. So I said, no, I'm not going to do it. And they said, well, we're going to do it for you. And they force-placed an insurance policy for me that doesn't cover me. It only covers them. And that was the genesis of a dispute with them that's been running for nearly 2 years now.
Well, we did reach out to Wells Fargo, got no response from them. It sounds just like your experience with them, no response at all. Are you surprised by that?
Welcome to the world of dealing with Wells Fargo. No, I'm not surprised at all.
You also then found an interesting loophole, or not a loophole, but you found an interesting law dating back to the 1970s, which enabled you to work this angle, which is they needed to respond to you within 20 days. They needed to respond to you with written responses to your inquiries. They didn't do so, and therefore you were able to place a levy on their office.
Ladies and gentlemen, that's why the arbitration agreement works, because it's a unilateral contract and they have a responsibility because you have a relationship with them to respond back to you. It's not just a 1970s law. It's known as the Restatement Second of Contracts. We placed it on the site, one of the first documents we put up there, Restatement Second of Contracts. We also take a look at the requests for to compel arbitration. So the request to compel arbitration, you will see that in that motion we include the law and we include the information as to why the unilateral contract works. They have an obligation to communicate with you. Because of that obligation, that's what forces them to respond. If they don't respond within the time frame, and even though that law says 20 days, you are giving them 20 days as well. You're giving them 10 days, and if they need more time, they have to specifically request that because it's part of the terms of the contract. Let's finish
Office and
explaining.
foreclose on them?
That's true. There's a law called RESPA, and there's a 20-day window that they have to acknowledge receipt of your request, and then they have 60 days to actually respond to that request. And if they don't, it's possible for you to collect damages and even additional fines on top of the damages. So
What he's referring to is the QWR, and that's RESPA, Qualified Written Request. They have 20 days to notify you that they've received your request, and if they do not respond within 60 days, respecting your communication, it constitutes a failure to respond, and they can be sanctioned for that. I've been telling that to several people. RESPA does work when it's done correctly, but you can only speak as to the accounting. You cannot speak as to other issues. So you always have to make sure it's associated with accounting. So we do a RESPA request. We don't call it RESPA. We don't call it a QWR, but we're requesting the exact same information. Why? Because the law says that they must provide that information. Hold on.
I took them to court here in Philadelphia through the municipal court system. I won a judgment. They ignored the judgment. The court advised them they had to pay. They ignored that court's advice. And so I got a sheriff's levy, and when they ignored that, I ordered a sheriff's sale on their branch in downtown Philadelphia. And they still weren't going to pay. But let me tell you, when the media coverage started and it was on the front page of the business section that their office furniture was going to be sold off to pay a judgment, I had a check in my hands the next day.
Brilliant. And I can imagine a lot of viewers this morning waking up wondering if they're in a similar position. Do you think that your story opens the floodgates for other people watching this morning?
I think it does. I mean, people ask me what I hope to get out of this, and one thing is if I wind up being the Johnny Appleseed of RESPA letters, I would absolutely love for that to be my epitaph. These RESPA letters are not difficult to write. There are numerous consumer resources sites on the internet. There's government sites on the internet that will help you with that process. And these RESPA letters, the banks are legally required to respond to them. So I would say to consumers,
So,
these are...
ladies and gentlemen, it is not just this gentleman who's telling you this. It is I who is telling you the same thing. And yes, 7 years ago, I was telling people that same thing. That's why it's included in the contract. All of your contracts say the exact same thing. Now, we also let them know that we're going to be filing a tort claim. We also let them know we're going to be filing a lien to perfect the security interest. They agree to the contract that you can do this. So nobody can come at you for fraud or anything because this is an agreement. Let me see if I can explain it to you so you guys understand. Ladies and gentlemen, they're trying to come at me and they're trying to ignore this instrument right here with that contract number. They cannot ignore it because the law says that only I and this company right here are involved. And the fact that I and this company right here are involved, they have no other choice. And remember, we did the United States military, United States Department of Defense, United States Armed Forces. Why? Because it's military jurisdiction. It's a continuing running challenge to jurisdiction. This is before there's any plea or anything else. Why? Because this operates as a plea agreement. Okay? We talk about the Trading with the Enemies Act. We talk about the March 3rd, 5th, 1933 acts. And then we talk about the March. This is the March 3rd is the 2038. March 5th is 2039. Okay. And then this is the Trading with the Enemy Act of March 9th, 1933. Okay. So it's all in your documents, those of you who have the incarceration documents. I can enforce your document. You will have to enforce your document. Okay. And I incorporated other contracts in this. I just realized that I forgot about it, ladies and gentlemen. This document is how many pages long? 97 pages long. This is 66,579 words. So it says right here, an American citizen of the United States of America have neither acted in rebellion or insurrection or as an enemy of the United States of America, and I, on behalf of my people known as Jehovah's Witnesses, the affidavit class, the McBrides, and the natural persons associated thereto, bring forth this my affidavit as proof of my being neither an enemy of the United States or a threat to the United States, finding that we are under a national military rule without constitutional authority is disturbing, and I must hereby bring forth my challenge to that position as unconstitutional. And since the Act of March 9, 1933 is an unconstitutional act, as Congress did not have the authority to delegate its powers to another branch of government, as that violated the separation of powers clause, we bring forth this our acceptance of your contract under the following terms and conditions, which are self-executing, binding, and irrevocable, coupled with interest. Do your research on this phrase right here. You see, in order for you to secure monetary damages, it must be coupled with interest. So let's see if we can do a little bit of coupled with interest. Not there. Let's go back to the Philadelphia guy. And we're going to, I would normally do a regular internet search on coupled with interest, but we're going to do, let's see. Uh-oh. We don't have coupled with interest. Give me 1 second, everyone. Hold on 1 second. I apologize for that. That's a SACOM member, and so we had to take care of him. What's going to happen right now is we're doing coupled with interest. So agency coupled with an interest is with an agent, when an agent has possession or in control of property of his principal and possesses a legal right against the interference by third parties. What is power coupled with interest? Okay, a power coupled with an interest is a power which accompanies or is in connection with an interest. The power and or interest are united in the same person. But if we are to understand the word interest, an interest is that which is to be produced by the exercise of the power, then they are never united. Okay, so coupled with an interest or coupled with interest. See, you have the two phrases, coupled with an interest and coupled with. Okay, so coupled to or coupled with. So let's continue. Let's see, I'm looking. No. What happens is, we'll do this one right here. License coupled with an interest. Other articles where license coupled with an interest is discussed. A license coupled with an interest arises when a person acquires the right to take possession of property located on someone else's land, as when a lender acquires the right to possession of an automobile that is located on private property after the borrower has defaulted on it. So they have to enter into a contract coupled with interest. If they do damages or whatever, they can be liable for that. Okay, what you're doing when your documents and your contracts are coupled with an interest is so that you can secure monetary damages. Okay, so coupled with an interest or coupled with interest is how each one of our documents are labeled. Ladies and gentlemen, to make this simple, to make this short, to make this what you need to know, you're going to have to go after your interest. What is your interest? Well, each one of your documents that you have, that you get an arbitration award, if you get an arbitration award, because you're not guaranteed an arbitration award. If you don't do your due diligence, if you don't have proof of service, you're not going to get an arbitration award because it will never stand up. So if you, by any chance, get an arbitration award that is a bona fide arbitration award, then you can go after your assets. You don't have to go to court. There is no law requiring you to go to court. Not even the FAA requires you to go to court. For enforcement of the judgment, you'll have to go to court because the contract says that. However, you still don't have to go to enforce the contract. You can go about just getting your interests taken care of. Okay? So you send a bill to the party. After you send that bill to the party, they default on the bill. You wait 90 days. That's the only information I'm going to give. I'm going to give a. I was looking at coupled with an interest, so that's why I said give a. That's the only information I'm going to give you, is that you have to wait 90 days before you can start trying to get the monies back on taxes. So do your research. You have 90 days to do research. Do your research during that period. You do your research during that period, and the 90 days goes by a lot quicker. If you don't do any research, then your 90 days is going to go by so slow, and you're going to be wondering what's going on, and you're going to be asking people, well, how come this and how come that? And they're going to be looking at you. It's how come because you didn't do what you're supposed to do. That's how come. And you're going to end up being in trouble. So do it right the first time and get it done right the first time. All right, so there you go. Because it is coupled with interest, there you go. That's your protection. And I like this one right here. So let's do this right here because I just saw that, the equitable powers. Now remember, those of you who are having property issues, what you should have done a long time ago is did a notice of assignment and signed your equitable rights over to someone else. And then you have to make an offer to purchase the property. But like I tell people, because there is no money, then you send them a coupon. You send them the one we have on the site. Do it right and you won't have any problems. Look, a power coupled with an interest is quite frequently referred to by the courts generally as contradistinctions to a naked and bare power, and it is important to have a clear conception of what is meant by these terms. The phrase power coupled with an interest is applied to equitable power. The second class above described, that is, the power in a trustee or quasi-trustee create estates. Hey, they get to create estates. So the trustee having the power to sell or lease is said to have a power coupled with an interest, since he has both the power and or the title. And the term is the same for the same reason applied to the case of a power to sell in an executor who are also given the estate to a land. On the other hand, in a case where it is referred to as a common law, readily occurred that no use is declared because it is equitable. It is equity. And the question suggests itself as to the theory on which, in such a case, the power can be regarded as operating. If the power is exercisable in favor of only blood relatives to the grantor, its exercise might be sustained on the theory of conveyance of a covenant, so on and so forth. Ladies and gentlemen, we just know that coupled with an interest is what you need. You need to document that, so that's why we documented that in every document. So what you're going to do is you're going to take the information, you're going to file your lien after you get your arbitration award. You don't have to wait to do that. You'll still send out the bill, the same as they do with you by filing their lien, and then they send you a bill. Okay? You have the arbitration award, and as long as the arbitration award has the arbitration award and a seal, and I believe SAA is providing not only the arbitration award and a seal, but they are providing a cover page, an authentication page of the notary, the arbitrator, and the arbitrator's seal. Okay, so you're going to get all of those documents, and they're going to give you a summary judgment. What you don't know is there are 2 awards. Let's do Let me see if I can find it, because I don't know where it would be. Okay. Well, we all know that a plea is the first step in granting the court jurisdiction. So, looks like there's going to be a lot of firsts. And I got to go all the way down to the bottom of the page. So, let's skip all the way down here. Yeah, we'll do right here. Okay. No, it took me all the way back to the top. And I don't need to be at the top. Need to be right about here. So let's go. No. Okay, so I can't find it on the first. That's not going to be the place. So let's do. Okay, so I put in district court, but again, I'm going to have to be all the way down here to find out the section. You're going to find that most of your contracts have it. They have the two clauses that actually help you. So I do that, and then I do this. Confirmation award in the District Court of the United States, a court of original jurisdiction, or any court of competent jurisdiction having original jurisdiction in accordance with the Federal Arbitration Act, the jurisdiction assigned by choosing wherein conditional acceptance for value agreement contract number blah 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 constitutes an agreement of an interested party in the event of the default in acceptance through silence and failure to respond when a request for summary disposition of any claims or a particular issue may be requested and decided upon by the arbitrator, whereas the designated arbitrator shall be chosen at random, who is licensed duly authorized in the event of non-acceptance and appointment of the arbitrator in a physical or mental incapacity as to act as the arbitrator, and the undersigned shall have the authority to select any neutral arbitrator. See, the undersigned has the authority. So we're going to go further. The respondents agree that the undersigned can secure damages by tort claim or financial liens of assets, properties held by them or in their behalf, for all injuries sustained and inflicted upon the undersigned for the moral wrongs committed against the undersigned as set, established, and agreed upon and consistent. So what I need all of you to know, I am not worried about them playing games with me, because I am more than covered, as you can see. Okay, and by the way, this one is for $10 billion, but already estimated in excess of $10 billion. Well, the original arbitration award is not for $10 billion. So I need them to keep racking up so that I can go back and get another arbitration award based on this arbitration, which was established before they changed the law. They don't want to play with me. And so I think I am going to ask for another arbitration as a result. Wait, don't tell me y'all went all the way back up top. We all the way down here. We started from the bottom, now we made it to the top. No, we're not going to that top. Okay, so give me a second. Like I told you guys, this one, there are well over 500 proof of claims. And you'll see that most of the... Somebody was asking a question about the infant estate. They said, if we've done the infant estate document, do we still need to do the QPAC? Ladies and gentlemen, the QPAC was created for getting control of the securities held in the infant estate, where the arbitrator declares you as having attained the age of majority. If you've already sent out the infant estate, you can do a modification by doing that request to the arbitrator to have the arbitrator declare you as having attained the age of the majority, because the infant estate talks about the age of the majority. So you can do that. I would do it if I was you, but I can't tell you what to do. That's your choice. Okay, just that simple. So no, it only mentions district court one time, so it's not going to give me what I'm looking for. All right, let's see. Ladies and gentlemen, as you see in all of the documents, we put the fact that you are private, non-consumer, non-household good, that the United States and automobile, a trust, a legal person, has been confirmed under USC 9102 and 9109 to be private property. This is something that's definitely going to have to go to the appeals court and the Supreme Court. But because this, and I want you to pay attention, here's the unique part about this. This document, this contract, is between myself and the United States. The same thing that Congress said regarding the Attorney General is the same thing that applies in this situation. This is a contractual agreement between the United States and the parties. That's why I followed the exact same format. Alright, with that being said, we're going to let all of you get back to your day. Thank you for allowing us to show you this thing about the coupled with interest, and we will speak to you the next time. Have a good day, have a good life, have a good night. Adios.